Greetings, friends of liberty. Yet again you find me in the TARDIS, just having returned after having visited with famed English legal scholar and judge William Blackstone in 1878. My commented to him how distinctly uncommon I thought his understanding of the common law was, and how very instructive his multi-volumed treatise Commentaries on the Laws of England. I did, however, dispute with him at length about his much-admired legal maxim, best to let 10 guilty men go free than to punish a single innocent man, I not being sure that the ratio should really be quite that high. In any case, he welcomed my debate, and we parted on good terms. Returning to 21st century America, today we deal with the work of another legal scholar, that of the University of San Diego's law professor Gail Heriot, who has written an excellent paper on the American congressional and judicial use of the concept of disparate impact. The paper's title is Title VII Disparate Impact Liability Makes Almost Everything Presumptively Illegal. I'd grant the paper an A-, and even though I've only recently arrived from the 18th century and haven't passed what you here in modern America call the bar exam, nor even taken the LSAT, I think you'll find an A- appropriate. First, a brief description of the term. Disparate impact denotes the fact that a test of employment can have different or disparate impacts on one group as opposed to another. So, for example, if an employer doesn't want to hire any employees who have committed a non-fatal felony, then given that blacks are about 3.5 times more likely than whites to commit such crimes, asking for that on a job application is very likely to result in fewer blacks than whites being hired, and that would be a disparate impact. The history of the governmental use of disparate impact is troubling but straightforward. The Civil Rights Act of 1964 explicitly allowed disparate impact tests, as it should, and indeed the act never would have passed if they hadn't been allowed. Second, the American governmental bureaucracy responsible under various civil rights acts for rooting out alleged racism, the Equal Employment Opportunity Commission, deliberately ignored the law and started banning most tests with disparate impact anyway. Thirdly, the Supreme Court also completely ignored Congress and their intent and deferred to the EEOC. And finally, in 1991, Congress reversed itself and more or less banned the use of employment tests that result in disparate impact. So one might wonder, does the EEOC ever allow companies to use tests that have a disparate impact? Only if they decide that there is a business necessity for that test. But there are numerous problems with this approach. First, many things are relevant to a job without being absolutely necessary. Number two, what can be necessary for the next job that you might get at a company is often not necessary for the first, meaning that you would have to create a different test for each of 100 different jobs. And thirdly, usually the EEOC, not the company, determine what's necessary. Very convenient for the EEOC. Now, in terms of racism, there's obviously, again, nothing necessarily racist about any given criterion with a disparate impact, like whether a person has committed a felony. What could be racist about that? So if such criteria are banned, instead of actually eliminating racism, by this test the EEOC in fact is attempting to privilege blacks at the expense of everyone else. That's the type of government you Americans have. A government that won't let a company, if it wants, test for the prior criminal convictions of a job candidate because black felons will be disproportionately excluded. Note, incidentally, as Supreme Court Justice Scalia once alluded to, that any legislation that in fact protects only one race, nationality, or sex is quite possibly unconstitutional, since it violates the Equal Protection Clause. And that's largely the history not only of Title VII disparate impact law on employment, but also of the totality of Titles VII and IX, to unconstitutionally try to protect only women and blacks from bigotry while overwhelmingly ignoring bigotry against males and non-blacks. And people wonder why political correctness and wokeness are increasing. Now, when I say that the EEOC is trying to privilege blacks by more or less banning criteria or tests that have a disparate impact, I mean just that. They're trying, but often not succeeding. That's because in many cases, the actual result of banning such tests is to actually reduce the chances of the most employable and productive black candidates for a job being hired. How does this happen? The economist Richard Vedder and others in a paper entitled Unintended Consequences Revisited described what happened after the first famous disparate impact decision of the Supreme Court in 1971 called Griggs versus Duke Power. After this decision, which approved the banning of most disparate impact criteria, the economists in our paper found that companies simply looked for other criteria instead. What are some of these? A college degree. So one result of Griggs is that since companies can't use regular tests, they disqualify you if you only have a high school diploma, because the EEOC doesn't ban that. And what has been the result? Well, since minorities are poorer, making it harder for them to afford college, and now in addition by the Griggs decision making it harder for them to prove their value to a company by doing well on a test, the unfortunate reality is that the actual impact created by Griggs has been to harm minorities more than whites. After the Griggs decision from 1977 to 2005, the income differential between those with and those without a college degree rose from about 45% to close to 90%. Ms. Heriot mentions not just this, but numerous other negative side effects. One being that employers are less likely to list job qualifications when hiring, since this can only get them into trouble with the EEOC. So the whole process of trying to find good people for your company, since you can't list the qualifications, and for job candidates, on the other hand, to find out whether a company would be right for them, is made harder. In addition, since the hiring process is more subjective now, without objective tests, it's more liable to be abused for office and company politics. Thirdly, employers may actually use stereotypes more, not less, if such tests are banned, since stereotypes, if true on average, can give the company some relevant information. Finally, as legal scholar Richard Epstein noted in his book Forbidden Grounds, potentially significant losses to the economy occur by not allowing the use of a general IQ test, by one estimate, up to 1% of yearly GDP. What's highly interesting, and Ms. Heriot's main point as her title indicates, is that disparate impact appears to occur in almost all cases. In other words, they appear impossible to avoid when using any test. She gives many examples, pointing out, for example, that with math tests, Asians are better on average. With horse racing, Hispanics make the best jockeys, and with numerous physical tests, men, being more muscular, are more suited. Ms. Heriot is so confident on this point that probably every test has a disparate impact on some group that she's willing to give $10,000 if proven wrong. So, dear listeners, I hope you enjoyed this brief review of Ms. Heriot's superb paper and can see some of the many contradictions in both the substance and application of Title VII of the Civil Rights Act. I bid you well, and remain as ever the Scarlet Pimpernel.